Number one, joint custody means equal time with the children. It's false. Simply because one parent has joint legal custody does not necessarily have anything to do with the amount of visitation that that parent will enjoy. For instance, one parent could have full legal custody over a child, yet the other parent may have the majority of the actual visitation time with the child. Number two, the courts in Oklahoma generally award custody to the mother. This is false. Under Oklahoma City child custody law, in a divorce matter, there's statutory language that says that courts shall, not would or should, but shall start with the idea of substantially equal time to both parties with the child. Number three, being designated primary parent in a joint custody plan is the equivalent of having full custody. This is false. Many people think this distinction carries more weight than it truly does. While it can become important for relocation purposes, the designation as primary parent, in my opinion, is oftentimes over-litigated. The designation as primary parent simply gives a deciding trump card to one parent or the other when agreements cannot be had. However, if an agreement cannot be had as to a major issue, then the parties will most certainly be back in court to litigate this issue, so the primary parent's decision may be a short-lived victory. Number four, it's always better to have no primary parent designated in our joint custody plan. Now, despite what I just said in myth 3, my opinion is simply that you must have a primary parent designated in a joint custody plan so that final decisions can be had. Without one parent being designated primary, all decisions in dispute would result in going back to court. Number five, standard visitation will allow only a very little time with my child. False. While many different counties in Oklahoma have variations of the standard visitation schedule, they typically will include visitation from Friday after school until Sunday or Monday morning every other weekend. Additionally, many times they will include a midweek overnight visitation on the week that you don't have the weekend. Substantial visitation during all major holidays and up to 5 weeks of visitation during the summer. When you consider all these visitation times, you quickly realize that even with standard visitation, this parent may enjoy up to 100 plus overnights per year, or approximately a third of the time. Number six, if I have full legal custody, my child will spend the majority of the time with me. That's false. Full legal custody does not necessarily mean that you have the majority of the time. Now, typically this will be the case. A full legal custodian will typically have the majority of the time with the child as far as physical custody goes. But it is not necessarily an absolute. Full custody simply means that one parent or the other has the complete legal custody and control over the child. What that really means is that they get to control the decision making for this child. Number seven, joint custody is appropriate in all custody disputes. This is certainly false. Joint custody establishes an obligation between the two parties to communicate about major decisions with the child or children. For instance, about schools, churches, medical procedures, and other major important decisions that would affect the child. These are all relevant considerations in a joint custody plan. When the parties are in a joint custody situation, there is an obligation under Oklahoma law for the parties to communicate with each other. So if you and your ex-spouse simply cannot or will not communicate regularly and successfully, then a joint custody plan simply won't work for your situation. Joint custody works when the parties are willing to cooperate and make it work. If your situation has become so adversarial that you can't communicate with the other party, then a joint custody plan simply will not work. Number eight, my ex-spouse will not let me see my child, so I don't have to pay child support. False. Your obligation to pay child support and your right to see your children have nothing to do with one another. While it is absolutely unfair for one parent to ever withhold visitation from the other, it does not excuse that parent from his or her obligation to pay any court-ordered child support. Alternatively, a parent who is not receiving their court-ordered child support cannot refuse court-ordered visitation to the parent who is refusing to pay his or her support. Number nine, once the divorce decree is final, custody and visitation cannot be changed. This is false. At any time, when one party or the other can establish a permanent, material, and substantial change in circumstances, that party may make a motion to modify the existing custody order. Although it may not seem so, the burden to prove that something is permanent, material, and substantial is a very difficult burden. Therefore, it's very important that your original custody order grants you the custody and visitation that you desire, since it can be very difficult if not impossible, to meet that burden to modify your order in the future. Number 10, my ex-spouse and I have an agreement as to custody, visitation, and support, so I don't need to go back to court. While the courts generally recognize agreements amongst the parties, the simple fact is a court order is effective unless and until it's changed. So even if you have something in writing, this may bolster or assist your claim as evidence to the court that an agreement existed, but many times it will not excuse a party from court-ordered obligations. It's therefore always a better practice to hire a lawyer, go to court, and legally modify the court orders if new agreements or arrangements have been reached. Especially when the parties are in agreement, these modifications can be accomplished quickly and at a reasonable cost.